The other issue that you'd want to think about is how you can protect your property from probate, but also protect it for the next generation. So I just want to give you a couple of definitions first before we go any further. And I have some notes here. How many people were going to be here? So I have about 40 of them. You're welcome to take them with you. And if they're gone before you get to them, I can, sure. I can give them, I can get your email and I can send it to you. Thank you very much. So as I said before, the history it goes all the way back 1,000 years, the trust, because the king kept on trying to get your money from you and you kept trying to get it from the government. So I wanted to give you some useful definitions of in the world of trusts. First of all, the idea of a trust is that it's a legal fiction. It's something that's made up. It's an entity that's created. And that entity is treated as if it's a person. It can own property. It can be subpoenaed for documents. It can be sued. It's not a person, obviously, but it's thought of as a legal entity. And the reason for that is because property is owned. When you own like this microphone or this pen, there are two things. Another legal fiction is that there's a legal owner of this pen and there's a beneficial owner of this pen. A legal owner is a person who can sell it and buy other pens and do anything he wanted with this pen because he's the legal owner. Now, there's also a beneficial owner, and that's the person who gets the pen, or the value of the pen, if it's sold. So you have in a piece of property, you have a trust owner, a legal owner, and then you have a beneficial owner. Trust does is it splits that legal owner from the beneficial owner. So anyway, so what you try to do is you try to create a trust so that it is protected. So there is a person who creates the trust who is a donor, and then who benefits from the trust, which is the beneficiary. So there are different types of trusts. There's irrevocable trust. There is a revocable trust, and then there's Medicaid. These are called liability avoidment instruments. So what you're trying to do is you're trying to put your property into one of these instruments, whether it's irrevocable trust, whether it's a revocable trust, whether it could also be a corporation. You could start a corporation to own your property, or an LLC. So there are these different types of liability avoidance instruments. And I put there that it's any document that protects the original owner of the property from liability. So when you have a trust, you have three types of people. You have the donor, you have the trustee, and you have the beneficiary. The donor is the person who gives the property. The trustee is the person who runs the property, and the beneficiary is the one who owns it. So let's say I create a trust, I'm the donor, give it. I put my son as the trustee, and then then my grandchildren are the beneficiaries. So the grandchildren are the people who benefit from any sale or the ownership of property. And my son would be the person who could sell it, improve it, pay taxes on it, and so on. So then on page 2, I tell you that there's two dilemmas that you have. The first dilemma is you have control, but with control comes liability. And as you get older in life, or if you work in a place that's in a profession, people like to sue you, or that think that you might have problems with, if you have a business, people are always trying to sue you, slip and falls, they don't like the merchandise, they want to sue you and all this. You want to protect your property. How do you do that? Well, in a business, Would you like? No, I'm sorry, but but I would like to. Anybody who wants one of their own, they can give me your email. I can send you. So let's say you have a business, and people in business are always trying to always have to avoid being sued, and for products, as I was saying, well, I sold you something, or you sold me something, and I don't like it. I want my money back, or you did something wrong, so on and so forth. If you just own, like I have my business is sole proprietorship. Now I control everything about it, but I'm also have liability. And so if I do something wrong, somebody can sue me, and my assets are up for grabs. So what do? I try to create an instrument that would avoid the liability. The problem, though, is that as I protect myself from liability, I give up control. So if you own, let's say you own a house, okay, that house is an asset that could be targeted by people if you have a liability towards them. So if you say, well, I want to avoid that liability. I want to put it into some type of instrument. I want to put it into a trust, or I want to give it to somebody. Well, you're giving up control, but you're avoiding the liability. And as we get older, and I'm probably one of the oldest ones in the room, you come into this issue of Medicaid, that when you go into a nursing home or when you have long-term care, the state steps in and helps pay for that. What do? Well, they feel that the taxpayer should be repaid, and they put a lien on your assets. So what do? You try to avoid that, avoid liability. You try to put it in some type of ownership that somebody else controls. But you give up control of that. That's the dilemma. That the more you control it, the more you have liability. The less liability, the less control. So then, if you put it into a trust, you give up control, but you also give up liability. So then you get a second dilemma. Second dilemma is, who do you trust? Right? I mean, I'm sure all of you have people in your lives that you trust. I have people in my life that I trust. I have 2 stepchildren that I love dearly, but I don't. One of them I would want as my trustee, and the other one I wouldn't. Not that I don't love them, but it's just the way that people are. Right? So you have to figure out in your life, before you do this trust, before you put it into an avoidance instrument, who do you trust in your life? And so the reason why you have to do that is because you're giving up the control to that person. The other problem that you have, the other part of the dilemma is, what do you want to do? What problem are you trying to solve tells me and other professionals like me what type of avoidance instrument that is good for you. If you're my age, you start thinking about a Medicare trust document. Then there's some problems with that, and I'll get to that in a minute. But that means that I have to give up total control of all my assets. Because if I don't, Medicaid will come in, take them, and get money back. And that will harm my children or my grandchildren. And so if you just want to protect your business, okay, we can put that into a trust, or we'll incorporate, or we'll have an LLC or something like that. If you want to, or another option is that and I'll get to those in a minute, you can put a joint tenancy. You can put your friend, your associates, your children as a joint tenant with survivorship. That way, if anything happens to you, then it goes immediately to them. Okay. So the 3 major things that you're trying to avoid is Medicaid liability, personal injury liability, and probate. Now, probate, you may know or you may not know, but probate is when a decedent's property transfers to the next generation or to its heirs. And so there's costs for that. There's opportunity costs. There's also taxes you have to pay. There's also fees you have to pay, and it takes a while. So you try to avoid probate. Well, you can do that by these different instruments. What are these different instruments, you may ask? I hope you're asking. One of them is a trust. Now, there are different types of trusts. There is a revocable trust, and there's an irrevocable trust. And if you know anything about the English language, you know what the difference is. The first one is that the revocable trust can be changed. The irrevocable trust cannot be changed. You have to think long and hard for the irrevocable trust before you do it, because it can't be changed. So the revocable trust, what you have is the participants. You have a donor, as I said, you have a trustee, and then you have a beneficiary. And this revocable trust is not acceptable as a Medicaid trust. That has to be irrevocable. Now, why would you do a revocable trust? Well, revocable trust you might want to do for a business. You might also want to put it in for to protect you if you're a driver, a professional driver, because then it's out of your hands. But then later on, if you retire or you do go into another line of business, take it out of the revocable trust. But it stays in place until you want to change it. You're the donor, you would be the trustee. Now, the irrevocable trust, as I said, of course, you can't change it. But that is something that you have to think long and hard if you trust the person that you're putting as the trustee. So let's say you have a house and you're like me, you're worried about what the future brings, and so you want to put it into a Medicaid trust. You think, okay, I'm the donor, I have to get a trustee, somebody I trust, and then I have to figure out who the beneficiaries are. Now, the beneficiaries have to be different than the trustee. At least one of them has to be different from the trustee. But you lost control. I could not tell, after I signed on the dotted line, I cannot tell anybody, the trustee or the beneficiary, what to do with this property. So what do you do? If you're like me, I live in this home, I've lived in the home for 30 years, I don't want to move. So what I do is I create what's called a use and occupancy agreement. That means that that it's sort of like a lease, but it's not a lease. It's a particular animal. It's like a unicorn. And a person can, so I have a use and occupancy. So even though I'm grumpy and I yell at my kids, the grandkids, they can't kick me out. They cannot sell the property without my permission. Okay? I can live there as long as I want. Nobody can get me out. So that protects you, but I have no control over the property. And because I have no control over the asset, Medicaid cannot take it, cannot put a lien on it, because that's the main issue that you're thinking about for doing this thing. Now, if I talk to my attorney and I say, well, that's not really what I want. What I really want is I want to save money on taxes. So I would suggest to you, well, then why don't you put the house into a corporation or an LLC? That's tax advantages. And I see a lot of, people who are much younger than I am in the crowd. That might be what you want to do, because what you need, I don't know, this keeps on going in and out. When you're young, oh, thank you. Thanks very much. So when you're young, like that gentleman, you want to get as much capital as possible, and so you want to save money on taxes. Remember, the king is always trying to get you to pay taxes, and you're always trying to get away from it. So you may want to put it into a LLC or a corporation. Now, those are two different types of that animal. But what it does is it saves money on taxes, and removes you from liability because the corporation now, another legal fiction, owns the property, but you own the corporation. So you don't have to worry about it. But there are problems with that that are too detailed to go into right now. But it's something for you to think about. Then I was talking to you about the joint tenancy with right of survivorship. So a lot of people do that. A lot of times people move in with their friends or their friends' children or their nieces or nephews or children, and they say, look, because you're taking care of me, you're so nice to me, I'm going to leave you my house. But we want to avoid probate, going through that process with the courts and having to, it takes a long time, and you have to pay taxes on it, and probate, you have to pay an attorney for it. So what do we do? Well, I don't want to put it into a trust because I'm not that old and I'm not that sick. So I'm not worried about Medicaid. So, but I want to give it, so I want to avoid probate. Well, okay, we put it in joint tenancy with right of survivorship. That means that your demise, or at a person's demise, I should say, it immediately goes into the ownership of the other person. A lot of times business people have that for properties, that you own properties and you don't want to get hung up in probate. So so the partners would be joint tenants of the other with rights of survivorship. That is a situation, that's a alternative, and that's a solution to whatever problem you might have. So remember, who do you trust? Do you trust your business partner? Do you trust your nephew, nieces? Do you trust your children? When I say that respectfully. All I can tell you is from my experience, elderly people have come into my office with their children, and I tell the children to leave. And I talk to the elderly people, and I say, is this what you want? And sometimes they say, no, I'm scared. I don't want to do this. Okay. And then we deal with that. So I'm just saying that, sometimes people could, in your life who you can trust and who you can't. But anyway, I won't belabor the fact. The last thing I would want to tell you is that if you own property right now, regardless of whether you put it into a trust, irrevocable trust, revocable trust, joint survivorship, so on and so forth, corporation, get a homestead. Take your property, and there's a document that I checked actually before I came here to make sure that my house had a homestead. What is it they say? The cobbler's children always go barefoot, something. So what it is a form that you can get online, and it's a homestead, declaration of homestead. And what it does is that it, at least in the short term, protects your property from any type of liability. If you get into a car accident, somebody slips and falls on your property, or anybody wants to sue you, it's protected from any debts. It protects it from being levied. So what's levied means that the sheriff comes with a court order saying, we own this property now. It protects the equity of the property. Now it's 120,000, 300,000. There's different levels, but it's a form you can get online at mass.gov. You fill it out. It costs $35 to register it, and it protects you from anything. It's the cheapest form of insurance there is. That doesn't help you, though, in terms of transferring your property to the next generation. All it does is it's just a short-term gap. So in terms of the Mass Recovery Act, Medicaid liens, the Commonwealth can lien and eventually take assets from anyone 55 years or older, or anyone in a long-term facility. This is on page 4. The state can take assets to be repaid. And the reason why is, they say, the theory, as I told you before, it's like, why should we have to pay if you have assets, you could pay for it. Anything that can be taken is bank accounts, real estate generally, or anything really of value. If you have the Mona Lisa in your study, they can take that. The amount to be recovered is all that is used. However, the upper reaches, in my experience, the upper reaches is 150,000. MassHealth Recovery will negotiate. And they won't pursue if your assets are less than 25,000. And they will not levy if your spouse is still alive living there, or if your children are living there and they have a handicap. That's pretty much boilerplate. The real thing comes down to the theory of, if you come in, when I deal with a client, I really just have to assess what it is that they want to do, how they can use the law to protect them. I come from a family in which, my grandfather was an immigrant from Italy, as you probably can tell from my last name, and he got cheated out of land because he didn't know. He was a poor immigrant, uneducated, and he didn't know what was going on, and they cheated him out of land. It happens. But so that's sort of the idea that I grew up with, that type of idea in my family, that the law needs to be understood before it can be helpful to people who really need it. So before I take your questions, I may have gone fast, but I certainly will stay and answer all your questions. I just want to leave you with one thing that Thomas Jefferson said that I paraphrase for my family. And that is, my grandfather was an immigrant, so his son could be a jeweler, so his son could be a lawyer. And the only way you can do that is if you have property or money going from one generation to another. And so I would suggest to you that you think hard. I mean, there are a lot of attorneys who can do this. I'm one of them. There are other attorneys who can do it. But I would think, if you're in a position with a family, or you are young and you want to protect your property, look into trusts, look into what the law would be to protect you. So if you have any questions, I'd be more than happy to answer them for you. Just one thing before I answer a question. I can't really go into specific stuff, but I could tell you generally. But how can I help you, sir?
When it comes to probates, how does power of attorney help? Does that help at all?
Yes, it does.
Okay.
Yes, it does. What I usually do is, when I do a will, I do a power of attorney and healthcare proxy. Now, a power of attorney allows someone else, again, somebody who you trust, could be anybody, but that person has the ability to sign your name for legal documents, or withdraw money, or to transfer stuff in your name if you're not around to do it. A lot of times people go, overseas, and they can't have access. That is a good instrument to help you, to protect you. Thank you.
Hi, Daniel. Thank you, sir. The first, how do you say your last name?
Ciccariello.
Ciccariello.
The CI in Italian is Ch. So people call me Chick, so you could call me Chick if you like.
Ciccariello. Very good. I walked in for the prayer a little bit late, and I saw you sitting back there, and I said hello.
Yes, sir.
What did you think of our prayer?
I thought it was beautiful. I hope that was the right word. I've tried. It's the first time I've ever experienced it in life.
That's what I was going to ask.
Yeah, and I thought it was very moving. And my tradition is from a Christian tradition, Protestant tradition, and it's not as unified. And I thought that was a good characteristic of it, was that it was unified. That I didn't understand
the quietness.
But,
the quietness.
Yeah.
That was very quiet. Most of the people, except the person leading the prayer.
Yeah.
Now I go to the technical questions. Sure. Thank you. The first thing that just a couple of comments actually.
Sure.
Just the difference between the legal and the beneficiary, the legal owner.
Oh,
and
sure.
You said the beneficiary is after the item is sold.
Well, what it is that anything that's owned, whether it's a car or a house or my pen or this bottle of water, the legal fiction is that there is a legal owner and a beneficial owner. And without a trust, it's together. So owning this, if I own this, I'm the legal owner and the beneficiary owner. So I can sell it and nobody can say, all I have to do is prove that I own it and nobody can say anything about it. And then what happens if I sell it to you for $1, I get the dollar because I'm the beneficiary owner. In a trust, you have the trustee decides whether he's going to sell it, rent it, or whatever. And then he holds it in trust for the beneficiary owner, which is the beneficiaries, which would be, let's say you have a trust. My mother had a trust. I was the trustee. My brothers were the beneficiaries. When we sold the house, the beneficiaries, my brothers and I, got the funds, but they couldn't tell me how to sell it because I was the trustee. I was the legal owner. Okay. So it's English. We get our law from England, and they love legal fictions. And this is a legal fiction. How can you tell me that? I mean, it's philosophical. How can you tell me that one person one person can own it or have a legal title to it, and another person has the beneficiary? I mean, they do it because they want to. Because they wanted to set up the trust to keep the money, so the lord who owned the property could tell people what to do with the land, you know. And then when the king came and said, "Give us some taxes," he'd say, "I don't own it. I don't have the beneficiary. You know, talk to the beneficiaries, my children, the babies." So that's the concept. That's where it came from, and it's developed since then. That you have a legal fiction like the trust itself. You have a corporation. That's a legal fiction. It's considered a person in some aspects. I mean, does that answer your question?
Yes, it does. The next one,
Yes, sir.
another quick one. Several instances you mentioned about who do you trust,
Yes, sir.
and you included your children, your partner, blah blah blah. You did not include any time your spouse.
Well,
Is there a reason?
that's because in an irrevocable trust, you would want to keep her out of the trust because here's another legal fiction for you: marriage. Okay, I mean, I say that respectfully. I've been married 37 years, so we're considered one in a lot of aspects. I mean, my wife and I are considered one in a lot of aspects. Legally, yes. So, an irrevocable Medicaid trust, the spouse would be considered, if your spouse was the trustee, it would not be covered under it wouldn't be a Medicaid trust, because you and your wife, under Massachusetts law, I hope it never happens to you, but if you ever get divorced, your spouse, you have to split everything 50-50. So she would be, but anyway, I don't want to get into that. Your spouse would be considered you. Okay. The other thing I probably didn't mention, that for the Medicaid trust, you have a look back of 60 months, which is 5 years. If you've ever been in prison, you know what 60 months is. Just joking. Anyway, so if you have it today, if you did it today with today's date, then you'd have to wait to 2029. This date in 2029, before you would be free from any Medicare liens. Okay, so that's an important thing to remember, is that it's a 60 month look back. However, when you get closer and closer to that 60-month period, they then prorate the last part of it. Okay. So they give you a break. So I mean, if you're a couple months shy, they give you a break on it. Okay. Does that answer your question?
Yes, it does. The very last one is the 150,000, the upper limit, the 150,000.
Yeah.
Is that fixed or variable?
It's not fixed. I had told somebody a little while ago that it was fixed, and I did some more research, and it's not. But in my experience, I've never, and people I've talked to, other attorneys that I've talked to, they've never seen it more than 150,000. So that's one of the gauges that I try to talk to people about, is to protect the property. If you have an asset that's worth $500,000, and you know the average or the upper limits are usually 150,000, then you have an idea of how to gauge it. But we can't. That's the reason why page 2, one of the sub parts is speculation. What are you going to do? What do you think that the future is going to hold? You know, are you going to be you're my age, in 10 years, what are you going to do? So you just try to do your best to protect your children and your wife and your grandkids. That's the only thing. I mean, that's my job right now. It's to protect my kids, my wife, my kids, my grandkids. That's it. So I'm done with fame. No, I'm just kidding. Did I answer your question, sir?
Any other questions?
So it's actually, thank you very much. 2 questions in one. So
Yes, sir.
for the irrevocable trust, so let's say the trustee passed away or the beneficiary passed away. So what's the situation here before?
Well, usually what we do is we have, in terms of the beneficiary, one of the ways that you try to foresee or deal with some problem that might occur is that you create what's called per stripes. Now, so when you have a beneficiary, let's say you have 2 children, you put the 2 children as beneficiaries, right? God forbid, well, if you don't mind me saying, God forbid, that one of them dies, then that person's children would take their share in a percentage. So if that person who died had 2 children, they would each get 50% of the share of the beneficiary. So you have the level here. You have the first beneficiary. He passes away, and he has 3 children. Each one of those children takes his share, but only a third each one. So you have 3 of them, only get a third. So that's how you would do it. Now, if a trustee dies, you have for successor trustees, and you would name one person. And if you name a person, I mean, you could name 20 of them, depending on what you think. There are some people that I do trusts for who are my age or older, and they're in their 70s, and all the people they trust are 2 years younger than them or something. So we have some trusts that we have successor trustees. We have 4 or 5 of them, because one passes away, then another. But if you don't do that, if you just have one successor, you have a trustee and then you have a successor trustee, then a lot of times what they do is they have in the provision of the trust that the court would appoint, or the beneficiaries would vote on it. Okay. If the irrevocable trust can be terminated, the irrevocable trust can be terminated, but none of the proceeds can go to the original donor. Because if they do, then it's their property, and it defeats the point of the irrevocable trust. Okay? Sir, can I help you?
Thank you, Dan, for covering number 1 and number 2. What's the idea of a trustee and can be, as a trustee, it can be 90% beneficiary?
Yes, you can have beneficiaries. what you need to do is you need to have at least one of the beneficiaries, not the trustee. Because if they're the same person, then the property merges back and it's no longer a trust. Okay, because you have the legal owner. Remember, you had the legal owner of this bottle of water and you had the beneficiary owner. If you're the same person, then you no longer have a trust. You have to have at least one other person as a beneficiary. But that percentage that they own of the property can be 1%. Could be 99%, could be 1%. But it just has to be one other person. Okay? Because if not, if it's just, Joe is the trustee and then Joe is the beneficiary. Joe owns both the legal owner and the beneficiary owner. So then you don't have a trust. Yes. Theoretically, you can do that. I've never seen that, but you can do that. I've seen beneficiary. I've seen several beneficiaries owning, 5%, 10%. I don't see any reason. I don't see any legal reason why you couldn't have it 1%. But you couldn't. But it can't be you. I mean, it can't be the donor. What's that? Yes. My understanding is that they would accept that. Yeah.
They will 99% my name too.
Well, if we're talking about a revocable trust, or if you're talking about an irrevocable trust,
Revocable.
the revocable trust, yes,
Revocable,
revocable trust, you can do that. Yeah. The irrevocable trust, as long as it's not the donor, it doesn't matter because you're just giving the property to somebody else. But the revocable trust, yes, you can do it 1%.
Thank you.
Sure.
Thanks again. I had one more question. I thought this would be a practical question because if you set up a trust, let's say with your son or daughter who's married, and I don't like to give the example of you, but someone, and that you pass away or you don't, or the person passes away, if that son or daughter who is the beneficiary or trustee in this case gets divorced, what kind of implications does that have?
Well, what I tell people then, what they do is they have a prenuptial agreement.
Okay.
It's the best thing.
Yeah.
You can put in the trust that the trustee, you're really talking about the beneficiaries because the trustee doesn't matter really. The beneficiaries, I would have them waive it as part the spouse of your child waive before the trust is created.
So you could put that in the trust itself.
Yeah.
Okay.
But she would have to, the spouse would have to
still agree to it. Yeah.
Yeah, would have to waive it. There would have to be a provision in the trust that spouse, because that happens a lot because, obviously, you have a house that's, these days it's worth a lot of money.
Yeah.
I've seen it. So, I mean, a prenuptial agreement, I don't know if that's something about part of your culture, but it's something that people do. I would suggest that it's done more often than it's not done.
All right, thank you very much.
Of course, when I was married, we didn't have anything, so it didn't matter. Who was going to get the most debts was really what. So, but anyway.
So if someone, hire you, let's say, to do the trust, do you keep a copy of that trust in your office? Is that will be part of the service?
Yes. What occurs in that type of aspect is it's the same as wills. Is that I make a copy of the will, and either the client keeps either the will, the original will, or the copy, or I like to keep the copy of the trust, and I keep that. I have a fireproof safe that I keep all these things in. I'm not going to tell you where it is, but and I'd like to have the client keep the original because they may have to deal with in a business aspect, So it also is good because it's something to flash around. I don't know if your father was anything like mine, but every time we did something wrong, he used to tell us, "Okay, I'm taking, just scratch your name off the will. And, you know, it's like the will must, I mean, that will must have been like 4 or 5 pages of just names scratched out because we were very disappointing to him.
Sorry, then excuse me, one more question. Let's say something that, you know, does happen and there's a liability. And the state, how would the state go about getting this? And when do we present that this trust?
Well, if you're talking about the irrevocable trust, what happens is that it has to be transferred with a deed to the registry. And so the owner of the, so it would be, you know, the Joe Smith irrevocable trust. And it would be in the, it would be on a deed and it would be signed, it would be in the registry so everybody could see it. And that's the first thing that MassHealth would look at, would be the registry of deeds. If it's not a property, but if it's a bank account or something like that, then usually then it would have to be transferred to another bank account, and that bank account would have that name, and it would have the trustee, you know, Joe Smith Trust, or you would give it to the MassHealth and just say, you know, here you go, and they would, first thing they would look at would be the date. Well, what would happen if there was, God forbid, if you pass away, then I just lost my train of thought. Okay, so what would happen would be MassHealth originally would look at the property and they would look at the date, and if it wasn't within the 60 days, they would then put a lien on it. 60 days, 60 months. Sorry, 60 months. They would then put a lien on the property, on the deed, so it couldn't be sold without them being paid off. Then they would come to you, they would come to your heirs, and they would say, you know, if you're selling that, you have to pay us back. And sometimes they would force the sale, and so they would have to sell the property, or you just pay them off. But if you see, that's the purpose of the 60-month period. I mean, sorry, that's the purpose of the irrevocable trust, because you want to avoid that. You want to avoid a forced sale by the state.
Thank you so much. It's me.
Oh,
here again.
Sorry.
For the prenup,
Yes, sir.
I thought it goes out of the window as soon as you have the first child, right?
No, sir. It depends on what depending on what aspect. Now, with divorce, again, there's this legal fiction. There's the financial assets, and then there's children. Okay, the financial assets owned 50-50 by the couple. If you have a prenup, what you say is that I'm coming into the marriage with all this money or all this property, and it's separate property. There's separate property and marital property. Marital property is what me and my wife acquired during the marriage. But I brought in very little. But whatever I brought in was, you know, I could say was separate property. So when you get a divorce, the prenup deals with those assets, whether they're separate or marital. Okay. But we're dealing with the children. You can never waive rights to children, and you can never waive. It's always under the control of the court. So when you get a divorce, it wouldn't deal with it.
That's exactly the case where actually the state of Massachusetts, as soon as you have a child, the prenuptial will be applied or opened for the benefit of the child, not
Right.
for the wife.
Right.
All right.
Well, it depends. It depends on really the situation. But I would tell you that the court, when you get a divorce, the court always maintains jurisdiction over the children, and whether they give it to so whatever you put in the, you know, if you put in the prenuptial agreement, oh, I'm never going to pay any child support. That's not going to fly. If it's going to say, I always get custody, that's not going to fly. I mean, the judge may agree with that, but it's not because of what the prenup says. Do you understand? Am I answering your question?
Yes, absolutely. But in the same time, what's the average cost of constructing a trust? Simple trust.
A simple trust? Well, a simple trust, I would say it's about 1,500. An irrevocable trust is about 2,000. I charge another $500 or $1,000 for will and durable power attorneys and healthcare proxies. Okay. Did I answer your question?
How about just, what do you call it? Constructing my own trust, and then I get what do you call it? The attorney just to
Well,
approve it.
you can do that. What you need to do is you need to make sure that you have witnesses, 2 witnesses, and they have to there has to be they have to be notarized.
Notarized.
Yeah, and they have to look they have to witness your signature.
And that will be legal, right?
Yeah, I mean, well, it depends on what's in the trust. I mean, you could have provisions in the trust that aren't legal, but theoretically, you could write your own trust. Sure,
Thank you very much. Appreciate that.
sure thing.
First of all, thank you for joining us today. But the question is, I got confused a little bit about the will and trust.
Okay.
So
Sure.
if I list that property, same property on my will, different beneficiaries, but at the same time I have trust, there will be any issues or conflict? I mean,
Well, so very good question. So I'm going to tell you another legal fiction. Okay. Philosophically, you could say that there's your body and your soul and your mind, or however you want to split it. And I don't mean to be disrespectful, but you could say it's this and this and this. Well, according to English law, there's another part, and that's your estate. Okay. So everybody has an estate. What's an estate? It's you and your property. Okay. And so when you pass away, you, of course, is no longer there, but your property stays and your estate stays. So if you have a will, or if you die without a will, then somebody has to control that estate since you can't do it. So they appoint somebody, or you have a will that tells the court that you want this person to do it. Okay. So anything that is probatable, any property that's probatable is in that will, is decided by the court or your will. Okay. Well, what's type of property are we talking about? We're talking about your house, your bank accounts, your personal property, not your life insurance, not your stocks. Those things are all federally controlled, so it's not part of it. What else is not part of your probate property or your estate? Your trust. Once you do a trust, you give the ownership, the ownership to somebody else. To who? To the trust, the legal entity, your best friend, which is your trust. For example, another part of a legal fiction is a bankruptcy. You go to the bankruptcy, you declare bankruptcy, you file bankruptcy forms. All of a sudden, they separate your estate from you, and you have a bankruptcy estate. So you thought that you had body and soul. Well, you also have a third, or how many others? That's another part of you, is your estate. So when you write a will, you say, I'm going to have all this property, this type of property, divided the way I want it. The trust is not part of that. Okay. So, yes, sir.
I wanted to ask you the 150. Let's say your house is worth $1.5 million. Will it be worth it to write, a trust? If you're trying to avoid this medical recovery, or it's just it's 150. It's not a lot of money.
Yeah.
But if it's 300,000 or 400,000,
Yeah,
then
that's
it's a huge amount.
Right, and that's the equation. Those are the figures you have to take into account. those are the equation. That's part of the equation. That a lot of times, but then you would want to have some type of, if you had that type of property or that type of value, that type of those type of assets, you probably want to do some type of not asset management, but estate planning that may involve somewhat of the irrevocable trust. The irrevocable trust is really for, I mean, in my opinion, it's really more for middle class, hardworking people. I mean, these other trusts and these other instruments of liability avoidance are, could be for richer people or for more people. I mean, for me, I would be concerned about an irrevocable trust as opposed to, because I have a modest house and I have hungry grandkids.
One more.
Oh, yes,
He mentioned the wells. Is the state law is above your will agreement? Let's say you wrote in your will, you gave your daughter half of what you gave your son. Then your daughter comes out and say, there's a discrimination. Can the state have the power to force, that change the will that you wrote?
Well, if you put in your will that I'm giving my son 75% and I'm giving my daughter 25% because she is a woman, then that may be discriminatory. If you're saying that I want to give, if I just like my son better, or I for other reasons that they won't go in to the explanation unless it's very obvious that it's, for example, I have one of my sons is married to a woman of another race. Some children are darker than others. If I put in my will that I don't want to give it to Joe because he's blacker than the other one or whatever, however you want to put it, that obviously is discriminatory and it will face a real scrutiny from the court. But as I said, I've never seen, though that question has come up before, I think, and if you're saying my religion says that I have to do it a certain way, you have the First Amendment, and that supersedes probate law. But I've never seen that challenge. Well, with no other questions, I want to thank you all for your attendance and for your, for listening to me anyway. And I really appreciated being here, and I really did appreciate the ability to witness your prayers, if you don't mind me saying so. I thought it was very, very educational, and I think more Americans probably should see it firsthand. Oh, please take as many, hand them out if you want. Thank you.
I want to thank you so
Yeah,
much.
Jazakallah khair. Thank you. Jazakallah khair for attending. So, it's been an hour and a quarter. So, and the attorney is going to leave his, a lot of us might have personal, specific to, whatever your property. You can grab his business card and give him a call and ask all the questions, private questions that you don't want to ask here in public. So we thank Dan for coming here. Jazakumullah khair, barakallah fikum. Assalamu alaikum wa rahmatullahi wa barakatuh. And inshallah حيكون عندنا كمان سيشن ثانية هنجيب محامي مسلم بحيث انه يشرح عن الوصية في الإسلام لأنه هذه مهمة جدا. جزاكم الله خير.